The fact of the matter is, the only thing I knew about the Coulier case comes to me from the media. I didn't even discuss the Coulier case with Judge Thomas. But the only thing that came through is I have read about that case through through the newspapers. Beyond that, I know very little. I know a bit more now because of these events, but not enough to have any thoughts with Judge Thomas about that case. In my meeting in the office, I asked about his health because he's fighting lung cancer and he's fighting vocal cord paralysis, and some of my colleagues out of Ocean County, the judges down there and some attorneys, have told me, a colleague in Lake County, occasionally I've asked, how's Judge Thomas doing because of his illness? And so I've expressed an interest in hoping that he recovers. When he happened to show up here, let me point out that it was not, as far as I know, his first night here in years, because the county prosecutor informed me that he asked if I had seen Judge Thomas about a month or so ago, and I didn't know Judge Thomas was in the building. Apparently he had come up. No one had told me if he even asked about me. I had no meeting with him, no consultation with him, only the knowledge of the prosecutors. They may have been in the building, but I didn't get to see him. And it may have been that the prosecutor saw him, but I did not. So he came back, and as he indicated in his interview with the officers, I came to see these old colleagues. And he didn't come up by any invitation by either me, as far as I know, anyone else. And his entry into my chambers was simply courtesy extended to a colleague. Little did I know what he had said allegedly before, and I'll take that as true. Little did I know what he said as after, and for purposes of my ruling today, I'll take that as true. The one thing that is not true is that we had any discussions about it and that I have expressed any opinion to him on how I would decide this case. I also asked about his retirement and about his work, and he indicated that he's doing some mediation. He also indicated he actually actively raises horses, but I knew that over the years he was raising horses, and that was part of his desired retirement. He was in chambers less than 5 minutes. We were interrupted by the bailiff, and the bailiff presented me with a note that a juror going out for lunch had handed him, and so I had to deal with that. And I told him so, and he left. You described events that have occurred about which I knew nothing until this morning. So I repeat, there's no conversation about this case, much less an opinion about how it should be decided, expressed to him or to anyone. It did not occur. The problem we have here, it's kind of a dual problem. This is the second attempt by the prosecution to remove me from this case. I denied the bind-over in this case, and the prosecution objected, appealed, and Judge Cooper overturned me. That's the way the process works. Judge Cooper's decision to appeal, Judge Cooper's decision was appealed by the defense, as it should be. And we got an opinion out of the Court of Appeals, which even more than, because I don't know Judge Cooper's opinion, only it was made on the record, but even more than Judge Cooper's opinion, that the Court of Appeals very clearly set forth the standards that it should have followed and why they overruled it. Clearly, an appropriate way this case has been handled because it guides this court in how this court handles these proceedings. When the prosecutor attempted to remove me from the case earlier, Judge Scott L. Kennedy heard it after I denied the motion, and Judge Scott L. Kennedy denied the motion. The prosecutor appealed that to the Court of Appeals and to the Supreme Court, who both declined to hear the case. The issue that came up on apparently on September 29th, that is clear from the documents that you filed. The court rule says that when discovery is made of grounds for disqualification within 14 days of the trial date, the motion must be made with forthwith. I do not know what forthwith means, but from Thursday noon to Wednesday morning, there's not been any motion or any information provided to me about why there might be a bias on my part for which I should disqualify myself, or an appearance of impropriety on why I should disqualify myself. That arises for the first time for this court to know this morning. That's after 3.5 days of testimony. This court is mindful that the Supreme Court has said there is a duty to sit. And that was very clearly the court's expression in Adair. In Adair versus Michigan Department of Education, two justices sitting on the Supreme Court had spouses that worked in the office of the Attorney General. And the one of the parties raised an issue that the justices should disqualify themselves from the case because the Attorney General is representing the Michigan Department of Education. And the Attorney General had spouses of the justices working in their office. But the court pointed out that there's nothing in which those spouses were involved in that had anything to do with the case. And they went on to point out that in invoking the appearance of impropriety standard, it's relevant where there are no specific court rules or canons that pertain to the subject, such as judicial disqualification, and there are none here that you've cited because you're relying on the appearance of impropriety. What guides us, the court said, is knowing and fully informing everyone of the facts and circumstances so that a reasonable observer who is informed of the facts and circumstances would know what the facts and circumstances are and then determine whether or not there's an appearance of impropriety. Justice Rehnquist observed when it was raised about his son appearing and representing another party in another case in the Supreme Court, that a well-informed individual would conclude that an appearance of impropriety does not exist simply because his son represented in another case a party that is also a party of litigation pending in the court. In this case, my problem is that someone else has created the appearance. I did not. I was not party to it, I did not know about it, and I was not privy to it until this morning. For these reasons, now that I have fully disclosed everything about this matter, Ms. Ralston, I'm denying your motion. And we have quite a few witnesses to go in this case. I'm prepared to go forward with this case and be heard. What do you wish to do?
Thank you very much for your time, Judge. We appreciate you hearing the motion set this morning on short notice, given the consideration that you did. Thank you, sir.
We're going to take a brief recess. Are you ready to go with further witnesses? The jury's still sitting back there. I can
Judge,
get-
I don't know, I know we have at least one witness here, and perhaps more, I
We can
believe.
proceed for an hour,
Okay.
and so that the jurors at least have something to go on. Ms. Kluth. Would you prepare an order to, I'm ready to do that for the recent statement on the order of council.
Perfect, thank you, Judge.
Thank you. Let's try to be ready by quarter to the hour.
Dave, it was nice to meet you.
Yeah, nice to meet you.
See you. That's why.
Hey, Bill, are you staying here or?
No.
Comfortable?
Could I get that, Mrs. Scarlett? Right, thank you.
Well, that's yours.
I'll make sure I get the name and title right.
Trust me, repeat what you saw today. So? Yeah, no questions.
Well,
Yep. Yeah. You did masterful. I'm sure they're, no, not okay.
Exactly.